tell me a little bit more about mediation under Indian law?
Very recently in India, mediation law is picking up, and the Supreme Court has formed a committee also. But what is interesting to note here is that how Indian law has started introducing concepts of pre-institution mediation, or the concepts of settlement before a matter comes for hearing. In that light, I must tell you about a few statutes or a few laws that have been recently enacted, in which there is a provision that before the matter gets admitted for hearing, the parties are referred to mediation or conciliation, and the court has to see if there is a scope and if the parties can really resolve the disputes before contesting it in the courts itself. One of the first laws that comes to my mind in such a scenario is the Consumer Protection Act in India. Now, enacted in 2019, which is a completely overhauled act. Previously, it was in 1980s, and now there's a completely new act in 2019, which has already been notified in India. Now, under sections 37 and 38, it talks about how if two parties have filed, or if one party has filed a matter in the consumer court under the Consumer Protection Act, the court has to first see if both parties can have a settlement. So they are, before the court starts hearing, they say, all right, you first go to mediation and try and resolve these disputes. Another very interesting act that comes to my mind is the Micro, Small, Medium Enterprises Development Act. Now, because India is a developing economy and a developing country, day in, day out, there are many, many micro, small, and medium enterprises that drive the Indian economy towards becoming a developed nation. Now, this is one of the most important sectors in India. Now, because this is a very important sector, there is, under the Act, a special provision provided which says that before you initiate any dispute, you first have to go to the Micro, Small, Medium Enterprises Facilitation Council. And that Facilitation Council will conduct the conciliation proceedings. And only in case those conciliation proceedings fail, will the matter go to courts. Now, let me tell you, it might appear as if it's not a very stringent provision, but it is, in practical purposes, one of the most strongest provisions. Every conciliation proceeding is taken very seriously by the Facilitation Council. And believe me, the success rate for the Facilitation Councils are also very high in India. Another statute that comes to my mind is the Family Courts Act and the Hindu Marriage Act and the Special Marriages Act. So you've taken care of the commercial aspects of it. Now, these are the personal laws that come into play. If you were to file a matter for divorce in India, court would ensure that you are sent for mediation right away. And there's also a cooling off period. So once both the parties decide to separate amicably, you're given 6 months time to even have a rethought, although it can be waived off. But even at that stage, the courts are trying to ensure that there is some sort of dialogue. And even if there's one chance that can be given to the family to survive, they'd go for that. So the family courts do not entertain matters before sending you to mediation. And in India, generally, there is a trend that is now being followed, that every enactment is now trying to bring in a pre-institution or an attempt to settle the matter or resolve it through conciliation. In this aspect, there's a very interesting judgment coming out of the Supreme Court of India in M.R. Krishnamurthy versus New India Assurance, which has changed a little bit about why conciliation is called mediation in India. Previously, it was not that. People used to term conciliation and mediation as separate. But now, after the judgment in 2019 by the Supreme Court of India, they've clarified that conciliatory proceedings are, in essence, the mediation proceedings. So there are many other acts which I would want to run through, but due to paucity of time, I can point out very briefly the Section 32G of the Real Estate Regulation and Development Act of 2016, the Section 12A of the Commercial Courts Act, which talks about pre-institution mediations. So these are just some of the enactments which I'm pretty sure you might be covering in later part of the lecture.